All rise. The Supreme Court of Guam is now in session. The Honorable Chief Justice Robert K. Torres presiding.
Hello, good morning. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA23-014, People of Guam Plaintiff Appellee v. Jesse Jr. Quintanilla Pinaula, Defendant Appellant. Appearing for Plaintiff Appellee is Attorney Nathan Tennyson. Appearing for Defendant Appellant is Attorney Levin Camacho. The panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Camacho reserves 3 minutes.
You may proceed, Mr. Camacho.
Welcome back to the Supreme Court, Mr. Camacho.
It's been a while, Your Honor. Mr. Chief Justice, may it please the court. The government cannot use a defendant's criminal history to relieve it of its burden to prove the elements of its case beyond a reasonable doubt. That is what happened in this case. There are 2 errors that warrant reversal in this matter. First, the trial court erred by impermissibly admitting evidence of Mr. Pinaula's criminal history. Second, even assuming the trial court properly admitted that evidence, the trial court erred by allowing the government to use that evidence for impermissible purposes. I will start by talking about the trial court mistakenly admitting evidence of Mr. Pinaula's criminal history. We have argued that there were 4 categories of evidence that the trial court should not have let in. One was Mr. Pinaula's pending felony case. The second was evidence of Mr. Pinaula's pretrial release conditions. The third is evidence of Mr. Pinaula's prior arrests. And the fourth is evidence of Mr. Pinaula's prior conviction. At trial, Mr. Pinaula did take the stand and testify on his own behalf. And during direct examination, he testified that he had previously had, quote, bad experience with police officers. And that is the reason why he left the scene. He also testified that the police had raided his home, had broken his items, and he believed that the police had, quote, had it out for him. Starting with Mr. Pinaula's pending felony case, there is absolutely no nexus between the pending felony criminal charges facing Mr. Pinaula and his prior experiences with the police. The trial court made no analysis, took no analysis of whether or not Rule 404 had been complied with or Rule 403 had been complied with. It simply allowed the prosecution to get into the fact that Mr. Pinaula had a pending felony matter. The second was evidence of Mr. Pinaula's pretrial release conditions. Again, his release conditions had absolutely nothing to do with his prior experiences with law enforcement.
And trial counsel objected to both of those, right? So we're looking at this under a harmless error standard.
Your Honor, Mr. Trial counsel objected to the introduction of the pending felony case, as well as he objected, and then after the objection, the pending felony case and pretrial release conditions evidence came in.
So it is a harmless error standard.
Well, Your Honor, I think we've argued abuse of discretion in this matter. Yes. So the analysis would be abuse of discretion, whether or not beyond a reasonable doubt, it did not affect the verdict in this case. The other 2, and Your Honor, I guess
while we review it for an abuse of discretion, and even if the trial court, even if we agree with you that the trial court erred in admitting the evidence, don't we still have to analyze whether we should reverse because it appears beyond a reasonable doubt that the error contributed to the verdict that was obtained? And don't we look at that under the harmless error set?
Yes, Your Honor. And I guess, so we have, what we are arguing is that there were 2 errors. One was the admission of the evidence, and the second is the use of that evidence during closing argument. So both of those would need to be analyzed, Your Honor.
And let's say we agree with you that the trial court erred in admitting the evidence. Why is that error not harmless error, considering the other evidence that was there that supported Mr. Pinaula's guilt, the testimony of the police officers, the physical evidence of the gun and the drug or the pipe in the car, his girlfriend, him leaving the scene.
Yeah, sure. I believe the test is whether it's beyond a reasonable doubt that it did not affect or contribute to the verdict in this case. And this was not a strong case for the government. There was another individual in the car. There was a question of fact as to who actually owned the car. There was testimony provided by DMV that whether or not it was Mr. Pinaula's car or whether or not he had borrowed the car. So the jury would have been presented and was presented with evidence that this was a borrowed vehicle. There was another passenger in the vehicle. The gun itself was actually found behind the passenger seat. So there was a real question as to whether or not Mr. Pinaula constructively possessed the firearm as well as the ice in this case. And Your Honor, I think when you conduct the harmless error analysis, you should look at the way that evidence was used in closing. Specifically, the government, for establishing the element of intentionally and knowingly, referenced the arrests, referenced the pretrial release conditions to establish an essential element. It wasn't a secondary, it wasn't meant to just correct the record. The government affirmatively used that evidence to meet its burden of proving beyond a reasonable doubt that Mr. Pinaula acted knowingly and intentionally. And I think if you look through exactly what was said, Rule 404B, I mean, just generally, you cannot argue propensity. You cannot argue a defendant is guilty because they have previously committed crimes. During closing argument, the prosecution said he has also acknowledged that he's been arrested 6 or more times in the past, and he couldn't specify the number of times he's been arrested. And this is when arguing whether or not he knowingly possessed a firearm without an ID. He's had different experiences. He understands how this works. He also testified that he had a closed case, a different case that he had already closed. So he understands what it means to be arrested and to go through the process. So when we look at the strength of the government's case, the government had to rely on all of this evidence, and it felt it had to rely on this evidence to meet its burden of proving its elements of intentional and knowingly. And I've looked at the prior cases, Morales, Callahan, and Finnick, and none of these cases have independent rules of evidence that would apply to the introduction of this evidence. And one of the things that's bothered me factually about this is that the court has never held that Rule 404 does not apply when there's this expanded realm of relevancy, quote unquote, opening the door. The government was required to provide notice of its intention to introduce any of prior acts or crimes or conduct. I believe our weakest argument is on the admission of Mr. Pinaula's prior criminal conviction, because a prior criminal conviction can come in. What we object to is the method that it was introduced. There was no analysis under 609, 404B. There was no notice that was provided of the intention to introduce that to impeach Mr. Pinaula. And again, it was used to argue in closing that Mr. Pinaula had a propensity to commit crimes, and the government and the jury could find him guilty based on that fact.
Well, the government appears to argue that, well, you know, perhaps notice wasn't required because they didn't intend to use the evidence, and it was Mr. Pinaula through his testimony that opened the door to the character evidence being admissible.
Your Honor, I believe if you look through the transcripts, the prosecution, it wasn't a blind cross-examination. They have a rap sheet. They know exactly the number of times that Mr. Pinaula has been arrested. They know exactly the number of times that he's been convicted. The prosecutor in this case, had the case numbers for both the pending felony case as well as a prior criminal conviction. And there's a suggestion in the testimony that she had the judgment available. And when we talk about the criminal conviction, Mr. Pinaula admitted that he had been convicted. But the examination didn't stop there. The prosecutor then asked, well, isn't this felony case? When was it closed? So even assuming the evidence of the criminal conviction could have come in under the rules of evidence without notice, the prosecutor went too far in terms of establishing the fact of a prior conviction. Once he answered affirmatively, yes, I have a criminal conviction, that should have been the end of the examination. But unfortunately, it did not stop there. And the prosecutor also relied on that conviction to establish that Mr. Pinaula had acted knowingly. Turning to the evidence of Mr. Pinaula's prior arrests. There is an argument that Mr. Pinaula testified he had bad experiences and that the government then was given an opportunity to question him about those experiences. We submit there is a difference between an interaction with the police or an experience with the police and an arrest. An arrest has significance because there is a conclusion that there is probable cause that you have done something wrong. And in this case, Mr. Pinaula testified that he did not know he admitted that he had been arrested. He admitted that he had been previously arrested. So at that point, there was no confusion to clear up. There was no record that needed to be corrected. But the examination didn't stop there. The prosecutor then said, is it more than 5, more than 10, more than 20? And continued to delve into it. And again, there was absolutely no analysis conducted by the trial court as to whether or not the probative value of that evidence. I believe there was one exchange when he asked, do you want me to include the times I've been arrested by a court martial? Which is a completely different scenario than being arrested by the police, which is what he had testified about before. So kind of going from, I believe, what the trial court could potentially have introduced the prior criminal conviction to the arrest. But the problem goes back to not only did the trial court allow well beyond correcting any impression that Mr. Pinaula was a law-abiding citizen, the prosecutor then used those prior arrests to argue that Mr. Pinaula had acted knowingly and intentionally when they argued that he possessed the firearm and the methamphetamine. The release conditions, Your Honor, I'm baffled as to what relevance the release conditions have to whether or not Mr. Pinaula acted knowingly or intentionally. Now, what the government seemed to argue, which was circular, is that he knew that he was in violation of his release conditions because he knew that he possessed a firearm and methamphetamines, and he knew he would get in trouble from the court. Well, possessing a firearm without an ID is independently a crime, and you did not need to have release conditions in order to establish criminality. That's what the government was required to prove. The same way it goes with respect to the methamphetamines. Possession of a Schedule II controlled substance is a crime. There was no need or relevance that he was on pretrial release in another felony matter. All of that was used to argue propensity, that he was facing criminal charges, he was ordered to stay away from these things, and that's why he ran. The government did not need to rely on that. This court has held that flight can be used as evidence of guilt. So the flight alone, the government could have introduced no problem. But to say that he fled because he was guilty impermissibly put that before the jury. And again, the prosecutor argued that with respect to both of the charges that there was a conviction on. The government has, and we would submit that even assuming that the trial court properly found this evidence to be relevant, Rule 403 still applies. This court has never held that Rule 403 is suspended because of this concept of expanded relevance or opening the door. And the trial court was required to conduct an analysis as to whether or not the introduction of this evidence was unduly prejudicial or its value outweighed the probative value. And again, there was nothing that this evidence added other than to show that Mr. Pinaula was a criminal and had a criminal history.
The court did no weighing of the probative value versus the prejudicial effect.
No analysis whatsoever, Your Honor. And I think going back to the notice, I didn't answer Your Honor's question. The government knew it was going to introduce this. Once Mr. Pinaula, he was on the witness list, there was a colloquy, he was going to testify. There was discussion of Rule 404B prior to trial, prior to Mr. Pinaula taking the stand, I think that morning. There was no indication whatsoever by the government that it would be offering his prior arrests, his pending felony case, his prior criminal conviction, or his release conditions. And if the government had provided that notice, we would have a record. Perhaps the trial court would have conducted an analysis of relevancy and whether or not the probative value outweighed or conducted the balancing test. But none of that happened in this case, Your Honor. So our position is that unlike Morales, unlike Callahan, unlike Finnick, there was no nexus between the evidence that was introduced regarding Mr. Pinaula's criminal history and pending criminal case, and the testimony that he provided on direct examination, and the court set no limits as to what the prosecution could have introduced. Our second point is that the trial court erred in allowing the government to use that evidence for impermissible purposes. So even assuming arguendo, the court finds that Mr. Pinaula opened the door and the prosecutor, the government, could have and properly introduced evidence of the prior arrests, the prior felony conviction, the pending felony case, and the release conditions. It was not permitted to use that evidence to argue propensity. Your Honor, the use of the introduction of the pending felony case and the release conditions, I believe, were objected to by trial. There was no objection during closing argument when the prosecutor made the three statements, Your Honor. But this really gets to what this court has held, and I understand it may not be mandatory that the trial court provide a limiting instruction, but there is a real danger in this case that the jury heard evidence of Mr. Pinaula's criminal history and used that to convict Mr. Pinaula. And how do we know that? It's because the government relied on it. The government, to establish intentional unknowingly for both of the crimes charged, commented on Mr. Pinaula's criminal history and commented on the release conditions. I believe we would be in a different scenario if it was just during cross-examination of this evidence came out and that was the end of that. And that actually is more analogous to the court's prior decisions where there was an objection or an introduction of evidence, and the question was whether or not the defendant had basically required or allowed to correct the record. This court has not addressed, well, when the evidence comes in, what can that evidence then be used for? And we submit that the rule of evidence still apply, and you cannot, and just general fundamentally fairness, you can't convict a defendant because he has a criminal history. And that's exactly what happened in this case. The government, I think, again, acknowledging the potential weaknesses in its case, argued, and I've read through that passage when it talked about the possession of a Schedule II controlled substance. This is, again, the prosecutor during closing argument. So let's look at this again. If you have the defendant, he's already testified. He knows he's not allowed to have Schedule II controlled substances. He knows he's not allowed to have a gun. He knows this because he's on pretrial release on another case.
So, Mr. Camacho, I've been sitting and listening in terms of what you said that the prosecution relied on. So, but did the prosecution rely at all on the five other police officers who testified? You know, one being the person regarding identifying the weapon, relied at all on the testimony of the girlfriend in the car, and was in reference to any other evidence other than the propensity evidence that you're arguing is in terms of prior convictions, prior arrests, the pending arrests, and the release conditions. So your point is that the jury did not at all consider the other evidence in the case?
No, Your Honor. That's our position is that this should not have been a JNOV. It shouldn't have been a judgment of acquittal. There was evidence that the jury could have found Mr. Pinaula guilty, but it was not a slam dunk case. And I think the government concedes, and we concede that the government can prevail using circumstantial evidence. But the testimony from the police officers about finding the gun, about finding the drugs in the car, about Mr. Pinaula leaving, all of those were used for permissible purposes. And the jury was allowed to draw a reasonable inference from that. What we object to is that if the court is to accept the government's argument that these four categories of evidence were introduced to correct the record, the government still was not allowed to use that evidence to argue propensity. And again, looking at the strength of the case, the jury could have found him not guilty based on constructive possession because of the fact that there's another person in the vehicle, and again, whether or not the car was borrowed. So we acknowledge and concede that there was other evidence that could have proven the government's case. But I believe if you review when the government talks about its burden of proving that Mr. Pinaula acted knowingly and intentionally, it almost relies solely on the release conditions and his criminal history. You do not see the government in the knowing and intentionally. It talks about flight and it says he knew, he must have known because he was ordered to stay away from it. There is no discussion about the police or the investigation. And quite frankly, the government didn't need to rely on that. But without a limiting instruction, there's a very strong likelihood that the jury impermissibly used that evidence and accepted the government's argument. Well, he's different. He's been through this before. He was already ordered, so he must have known. If the court were to accept or to rule that the trial court properly made the evidence, this court can still vacate those convictions based on the use during closing arguments. That's our position, Your Honor. And whether or not it's beyond a reasonable doubt the error did not contribute to the verdict. Again, it's the government's reliance. It was almost solely on, especially the pretrial release conditions. I still do not understand how pretrial release conditions in any way are relevant to establishing whether or not Mr. Pinaula constructively.
What about the standard of review under plain error that applies for the two alleged errors in reference to the prior convictions and prior arrests? Those are subject to the plain error standard of review, aren't they?
Yes, Your Honor. What even though we have the higher burden of establishing that the court committed plain error, I believe when it comes to the use, the admission, I could understand the court might have some reluctance on the prior arrests and the prior felony conviction. But when it comes to the use of that evidence to argue propensity, the trial court committed plain error. I don't think there's any way that you can argue that the trial court could have allowed them to argue propensity, whether or not it was clear under Guam law that you cannot argue propensity, whether or not that error affected Mr. Pinaula's substantial rights, and whether or not reversal is necessary to maintain the integrity of the judicial process. So even under that higher burden of proof, when it comes to the admissibility, I can understand the court's concerns, but when it comes to the use of that evidence, the trial court absolutely committed plain error. It becomes it. I believe. Well, this court could find on any one of the four categories of evidence, and any one of the four would warrant vacating the conviction and remanding the matter to. So the court wouldn't necessarily need to reach the prior arrests or the prior criminal conviction if the court finds that the trial court erred in admitting, as an example, the pending felony matter or the release conditions on the pending felony matter, and then the use of that.
Mr. Camacho, there was an agreement not to bifurcate the felony and release portion of the charges. Was there an agreement during those discussions that the pretrial release issue would not come up until after the trial concluded?
There was a stipulation to bifurcate. There was a special allegation of commission of a felony while on felony release. And there was a stipulation that it would be bifurcated and that the issue of the felony release would be heard after the trial on the underlying charges. And we've raised that point that the prosecutor and the court both agreed that there would not be any evidence introduced that Mr. Pinaula was on felony release during the trial. I don't know if they got as specific as to stipulate to whether or not the release conditions, but if you are stipulating not to talk about the pending felony case, it's almost implicit that you're not allowed to talk about the pending or the release conditions that Mr. Pinaula was under at the time of the offense.
So it seems to me that makes the notice even more important.
Absolutely, Your Honor. And I think it actually, in terms of, I don't say being ambushed, but the government clearly understood, they alleged that he was on felony release. There was that intention, but there was an agreement not to introduce it at trial. When Mr. Pinaula when there was notice to the government that Mr. Pinaula, actually even prior to Mr. Pinaula, and this goes towards the disadvising Mr. Pinaula and the decision whether he wanted to testify. I know there was a colloquy that the judge went through that they would be able to bring up his prior criminal arrest. But if the government had actually said, if Mr. Pinaula testifies, these are all the things that we're going to raise, I'm sure that discussion with trial counsel would have gone a little bit differently, and or the direct examination would have gone a little bit differently. There was, thank you, Your Honor, for pointing that out, that there was a stipulation prior to trial that the government would not raise the issue or the fact that Mr. Pinaula was on felony release at the time of the offenses. If there are no other questions, I'll reserve the remainder of my time for rebuttal.
All right, thank you, Mr. Camacho.
Thank
You
you.
will have 5 minutes remaining. Mr. Tennyson?
Thank you, Chief Justice. May it please the court. The real issues I think the court's looking at in this matter, and there's a few levels to go through. There's Rule 404B, there's opening the door, there's plain error, there's abuse of discretion. And I'd like to start just with under abuse of discretion, the proper standard is looking at harmless error standard. Part of that standard is looking at the prosecutor's conduct with respect to improperly admitted evidence. And really a key factor in this case is why was this evidence admitted? Why was this brought in? Why were these questions asked? A big component of this case was Mr. Pinaula had been at the gas station. The police had stopped him, wanted to ask him questions. He asked permission to go to the bathroom, and then he left. And a big question has been, well, why did he leave? His girlfriend was asleep in the car. There's testimony indicating it was his car. He testified he was borrowing the car, but he left the car there and he left the gas station on foot at night. So, and there had been a prior stipulation regarding this stuff. The issue was bifurcated into a separate trial. It was pled, I believe, for an enhanced sentence. And an enhanced sentence, it was going to be brought up in a different proceeding. And the prosecution, the government had agreed not to raise those issues. Now, we run into the problem here, and there's been discussions of, well, there was no notice. The government didn't provide notice. They're going to raise these things. And it was really ambush. And it can be said, ambush in both ways. Mr. Pinaula took the stand and testified as to his intent for leaving the gas station. And he indicated that the police had something out for him. They'd they'd broken into his home in the past, causing damage. He said he didn't know why his house had been raided, but the police broke in, they broke TVs, they threw undergarments of his and his roommates around, they poured acetone and glue all over his food, and they just caused general damage. He particularly stated, I'm not saying all law enforcement are bad, I just didn't feel safe at the time. Now, the people's position now is the door has been opened because when Mr. Pinaula made that statement, he was saying basically, I left the gas station because the police had taken improper action against me in the past, and I had some fear that they'd do so again. And Mr. Pinaula's counsel raises the fact, well, the government was ready, they had case numbers, they knew how many times he'd been arrested, and that's evidence that they plan to use it regardless. And I'd say,
But did the evidence that was introduced go beyond the scope of the initial inquiry regarding his interactions? I mean, to bring in all of the prior arrests, the convictions, the felony on release, and
Yes.
the release conditions?
That's a good question. So I think to really dig into that, we need to look at each of the four issues that was raised. One was how many times was he arrested? Two was the conviction. Three was the pre-release order and the conditions. And four was the other ongoing conviction action. Now, I'm sorry, criminal action. He resolved that through the court. In looking at those, I would argue and suggest the court look at, he did indicate that he had prior bad experiences because the cops had it out for him. However, he had prior experiences. He did appear to have a fear of being arrested, whether for good cause or bad. That's something else. The conviction, and I've struggled with that one looking at it. When I look at that, I look at that in light of his statement regarding, they just broke into my house and rummaged through things, threw stuff around and caused damage. I view the testimony, the conviction is leading towards why that raid happened, why his house was broken into. But more generally, I view that line of questioning from the prosecutor in an attempt to get to, I think the one issue that was objected to, which was the pre-release and the conditions. And Mr. Pinaula is arguing, well, that was just brought in to show propensity of him being a criminal, that he's done this before, he'll do it again. When I look at that, I view it as more of a, if we look at Rule 404B, character evidence is not admissible to show conformance with that character, but it is allowable for certain things like motive, intent, lack of mistake or negligence. And in this case, if we're looking at the conditions of the pre-release, and this was objected to, and the trial court did have a discussion on after that. Trial court did provide some limitations, said to the prosecutor, don't want you digging into every single case he's had, just what's relevant to the immediate issue, which is Mr. Pinaula's departure from the gas station, his concerns about the police, and really why he may have been leery of the police officers. And after that point, it was limited to just what were the factors of that pre-release order. The pre-release order is important because, as Mr. Pinaula argues, there's circumstantial evidence in this case. One of the inferences is, why did Mr. Pinaula leave the gas station? Now, if the gun was his, if the meth pipe was his, under that pre-release order, he was prohibited from having those things, didn't want to be caught with them. And that would be a basis to inform his motive for leaving the gas station. It's not to show propensity that, he owns those things and he's had prior orders against him. It's to show the motive or the reasoning for why he fled from the scene. As we raised in our opening brief, had he been, had he borrowed the car, had he been unaware it was in there, maybe he still would have left the gas station. However, there is an inference there that because of that pre-release order, that he did have a motive to not want to be in the vicinity of that car if he knew the meth pipe and the gun were in the car. So that's, I believe, really where the opening of the door comes in. And even under Rule 404B, there's been argument that they were trying to show propensity that he was a criminal, to besmirch his character. Even if we look at the closing arguments, when the prosecutor is talking about these issues, it's really more of a, there was a prior order. He knew you can't have a gun. He knew you can't have the meth. It wasn't an argument in the vein of he's done these things before and we have another case, he's done it again. The prosecutor did limit their discussion of this just to the knowledge or the intent as under that order relative to the gun and the meth. And defense counsel, Mr. Pinaula's counsel, didn't object to that that closing statement. Actually, Mr. Pinaula's counsel also in his closing referenced the conviction, referenced these other issues and attempted to mitigate it. And as we look at the argument regarding the jury instruction, I think there is some wisdom in looking at, there was quite a bit of other evidence. There was police officers. The girlfriend testified that Mr. Pinaula had bought the car from her mother, I believe. And as a result, it was his car. He'd be expected to know it's in it, gun, meth pipe, everything else, even if it wasn't within his immediate sphere of control. Sorry, I lost my train of thought. Anyway.
You were talking about the other evidence also.
Yes. But when we're looking at, thank you. That did jog my memory. There is some wisdom in saying that both the defense counsel and the trial court had some discretion in imposing a jury instruction. These extra statements compared to the other evidence were not in my opinion, prejudicial, the people's opinion prejudicial, because there was significant other evidence that a reasonable trier of fact could have looked at and come to a conclusion that it was his gun, it was his meth pipe, based on the evidence they heard. And on that basis, do we really want to have a jury instruction bringing to light the fact to the jury, hey, you shouldn't listen to this minute or two discussion in closing and during testimony that he had been convicted before for a similar thing, that he had gone through these arrests, because the moment you bring that up, jury may give undue weight to it again by seeing that jury instruction. Well, if it's not important, why did you give us a jury instruction on it? There is some hazard there. There is some danger there. And based on the closing arguments, I think the prosecutor addressed it properly in it so far as they did address it and discuss it. And I believe defense counsel did sufficiently mitigate that being brought up. And even if we're looking at, in Mr. Pinaula's brief, he cites the People v. Anderson and People v. Kittigwa regarding admission of this kind of prejudicial 404 prior convictions, prior arrests. In People v. Anderson, that testimony was elicited from the defendant, one, in response to testimony from another witness. So the defendant hadn't talked about anything that would have required these questions asked of him to clarify the record. Another witness testified on these issues. Defendant comes on the stand and the prosecution just asks him flat out, have you been arrested before? Have you been convicted? And the court looked at that, and I believe that's a California case, and said, no, that's prejudicial. That's worthy of reversal. You can't bring that up under Rule 404 without doing the balancing test. People v. Kittigwa involved prosecution raising the prior arrest on its own again. It wasn't in response to the defendant opening the door. It was just raised in response to, actually, no, that's Kittigwa. Anderson was, I apologize. First case I discussed was Kittigwa. Anderson involved prior arrests and crimes, and the prosecution raised that solely for the purpose of impeaching the credibility of the defendant, saying, well, he's a liar, he's been arrested before, he's done it again. This case is distinct from those because this really is about Mr. Pinaula's statement as to why he fled, his experiences with the police and what informed that. And when he discussed that, the prosecution had to clarify, well, aren't there some other factors here that might influence your decision to leave, your motive to leave? And they did that. The trial court did limit. The trial court did, after objection, say, no, just what's relevant, just the pre-release. Don't dig into these other, there's some question as to how many times he was arrested. I mean, prosecutor asked, was it, more than 5 times? He said, yes. More than 10, no. And then he said not more than once. In regards to the marshals, the prosecutor didn't actually raise the marshals. They were asking about arrests, and Mr. Pinaula answered the question, and then he himself brought in the marshals into the equation. And then that's when the prosecutor started asking about, well, how many times if we look at the marshals. So after we look at the initial level, the facts, the 404B, we're really looking at the standard of review. For 2 of these issues, we're looking at plain error. For the other 2, we're looking at abuse of discretion. Now, the ones under plain error are the number of times arrested and the previous conviction. There was no objection. And for that, we're looking at, was there an error? The people argue that there wasn't an error due to opening the door. That's something the court's going to have to determine and make that decision. Was the error clear or obvious under the current law? Under opening the door, did the trial court have discretion to be able to look at that and say, I think these are relevant in order for a clear record to be set forth? The people would argue that it's not a clear or obvious error, but again, that's for this court to look at in totality and decide. Did the error affect substantial rights? Now, on that one, there was substantial other evidence. And as we're looking at these kinds of issues, I believe this is also Kittigwa. Evidence is sufficient if, after viewing the evidence in light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. Now, if we're looking at substantive prejudice or error affecting substantial rights, this wasn't the only evidence about this. And insofar as it was evidence, it didn't implicate that he possessed the gun in this case or he possessed the meth pipe in this case. That was the result of testimony from other witnesses, the girlfriend, the police saying this was his car, And as you know, girlfriend said, it was his car. It wasn't my gun. It wasn't my meth pipe. The jury,
Why did the prosecutor have to make reference to it in closing? I mean, I know you tried to explain it earlier, but it seems like there was an undue emphasis on
yes.
that.
I can only speculate as to the prosecutor's state of mind when I was reviewing it. I think there's two ways to view it. The first way is Mr. Pinaula's interpretation, which is it was raised to show that he knowingly had the gun, he knowingly had the meth pipe, and that was a violation. And as a result, that evidence was prejudicial to him. When I look at it, I view it as more of a statement or a restatement of the fact that he had this release condition. Not that he knew he had the gun or he knew he had the meth pipe, but he knew he couldn't have a gun and he knew he couldn't have a meth pipe because he was under a prior order saying that, hey, you can't have those things, it's bad. I think what the prosecutor was trying to get at was more of tying it into the motive for why he fled. That wasn't what was done. It was just, that wasn't how it was discussed. But I also don't think it was raised in a sense of, you know, he did it before, he did it again. I think it was solely to try to discuss that he had knowledge that these things were illegal. As Mr. Pinaula raises, he already admitted that. So there is potentially some issue there, raising it again on closing and bringing it up. And for that, this is where the abuse of discretion and the plain error standards arise. You know, there was no objection when it was raised on closing. And the factor it really ties into, which we're discussing now, is affecting substantial rights. Now, the jury was able to weigh a lot of other evidence they heard. This wasn't just a matter of, we don't have a lot to go on other than this prior conviction. I'm not sure if they stated what the conviction was for. Really, they just dived into what the substance of the pre-release was. And even if that was discussed at closing, there was substantial other evidence the jury would have looked at, considered, to make a determination separate from the pre-release that he at that time possessed the gun. It was his gun. It was his meth pipe. They didn't determine that he borrowed the car. It was someone else's gun. He was unaware it was in there. And then the final element of plain error is reversal is necessary to prevent a miscarriage of justice and to maintain the integrity of the judicial process. And I think that's a pretty, I would say a big hurdle, but there's a few things going on in there. One thing we look at is the discretion of the trial court in opening the door. The second thing we look at is the degree of the evidence that came out. How damning was it? How prejudicial was it relative to the other evidence that the jury heard? And I think based on the other evidence, even if this statement had not been discussed in closing argument, the jury still, I think, would have found beyond reasonable doubt that the gun was Mr. Pinaula's, the meth pipe was Mr. Pinaula's, the car was Mr. Pinaula's. They heard evidence to support that. Nothing in this arrest, conviction, pre-release condition, testimony discussed those factual factors. It was solely as to his knowledge that you can't have those things and informing his intent as to why he fled the scene. And the jury had to consider also, why did he leave? Why did he leave his girlfriend there, the car there, whether he borrowed it or was the owner himself? That was a big factor that the jury had to look at and consider.
I have the same concern that Mr. Camacho raised.
Mhm.
Why was it necessary to talk about the pre-release conditions when that's already against the law? To possess a firearm that's not or unregistered and a controlled substance.
In regards to that, I would say that that issue was brought up not so much to inform, you know, it's illegal to have the gun, it's illegal to have the meth pipe. That issue was raised because when Mr. Pinaula testified, he stated, well, I fled the police. I left the gas station. I left the gas station because I had bad experiences with the police. They've broken into my house. They've done all these things to me. And that's really why I left. So the pre-release comes in because there was a standing order against Mr. Pinaula saying you can't have any gun and you can't have any meth. And if you have any of those things, you're in violation of the order, it's going to cause a problem. So that issue was raised because that would have informed Mr. Pinaula's state of mind when he left the gas station. If he knew the gun was in the car, if it's his gun, if he knew the pipe was in the car, had meth, and he knew that pre-release order was in place, that he'd get dinged under it if he was caught with those things, that would have informed his intention or motive for leaving the gas station. And I believe that's why it was raised. It wasn't raised to demonstrate that he had the gun or he had the pipe. It was to show that he had some intent or motive to leave beyond just his statement of, well, the police have broken into my house before, I had bad experiences with them. I believe that's why it was raised. And I know there was a stipulation saying they wouldn't raise it earlier. The problem there is when Mr. Pinaula raised that testimony, the prosecutor had to address it to clarify the record as to what may have informed his intent. And ultimately, the court will have to look at that and decide if that was within the scope or the invitation of Mr. Pinaula's testimony, or if it was outside the scope. I think for the purposes here, it was within that invitation, but that's just my opinion. Yeah, the second part we're looking at is the abuse of discretion. And as I said previously, proper standard for abuse of discretion is harmless error. And when we're looking at harmless error, we have 4 factors. One is overall strength of the prosecution's case. There's lots of testimony from police, other witnesses, that he didn't have a firearm ID. It was his car, gun was there, pipe was there. Jury heard all that, weighed it. Number 2, prosecutor's conduct with respect to the improperly admitted evidence. And this is an important one for this case. So should the court determine that that evidence was improperly brought up, improperly referenced, admitted, how did the prosecutor use it? And in this case, prosecutor used it at closing to discuss really knowledge, intent. When I was looking through the closing argument, I didn't see anything in there about arguing that he has a propensity to this kind of thing. He did it once, he did it again. It seems it was focused on his knowledge as to not having the gun, not having the pipe, and he couldn't have those things. As we've discussed, he already knew those things. But the balancing act here is the court looking at how prejudicial would that usage have been towards the jury's determination. And I think when we weigh that against the other factors, if the court finds that evidence was improper, the prejudice is low. And that ties into the importance of the wrongly admitted evidence. It didn't tie into the basic elements of the case. Now, let's say he'd had a prior conviction for a DUI or something in the same vehicle, and they'd stated it was his car there, and they brought that in to prove it was his car, even if it wasn't his car anymore. Would that be prejudicial? Yes, because that ties into a factor in the determination of it's his car, the things in his car belong to him. Same if he'd had prior conviction for use of carrying that gun with him. He's been previously convicted for having this gun before, and that means that it's still his gun. That would be prejudicial because the jury would look at that and say, well, it was his before, he was convicted, so he's just doing it again. In this case, it wasn't tied to the factors of possession, it was tied to knowledge or his motive for leaving. Be based on sufficient evidence, and I'm going to tie this into the fourth, I'm sorry, that's something else. That's people v. Evaristo elements for 404B. Whether such evidence was cumulative of other properly admitted evidence. I would say this evidence was unique in informing his motive for leaving the gas station, and it didn't really inform the other evidence as to, was this his gun? Was this his car? Was this his meth pipe? That was all established by other evidence. Really, the risk, as Mr. Pinaula is arguing here, is merely by bringing that in, it was prejudicial by showing he had a propensity for criminal activity. There's also, if we look at 404B for evidence regarding prior bad action crimes under people v. Evaristo, there's elements there we look at too. I don't know if those are particularly relevant here, but let me just see if, there's a discussion of remoteness in time. So this was a relatively recent event. He was still under the pre-release order. Now, if this had been 10 years ago and it was no longer in place and it had been brought up, that would definitely change the calculation. However, considering it was an active order at the time, it did inform intent and motive. Let me see. I think I've covered almost everything. Let me just run through. When we're looking at the jury instruction itself, since there was no objection, it is reviewed for plain error. That's People v. Cox. And the standard for looking at a reversal on that is People v. Wesson. And the standard is if it's not reasonably probable that the defendant would have been acquitted, but for the absence of the jury instruction. And as we've stated before, there was quite a bit of other evidence the jury could have based its determination on. A reasonable trier of fact could have found that possession of the gun and possession of the meth were justified beyond a reasonable doubt under this evidence, the testimony of the girlfriend, the police officers. And with that, I have nothing further. If there's no further questions.
Right. The court has no further questions for you.
Thank you very much.
Mr. Camacho, you have 5 minutes.
The evidence that was introduced in this case that we're talking about, it isn't regarding a secondary issue. An essential element of both of the charges that Mr. Pinaula was facing is that he acted knowingly or intentionally. What the prosecutor did in this case was use the release conditions as a proxy for establishing guilt. That's it. It's very straightforward. He is guilty because he's guilty. He knows because he knows. That is an impermissible use of evidence that should never have come in.
What about the argument that it was for motive for leaving the gas station and that's why it was introduced?
Your Honor, if you tease that out, it's like, well, his motive is he's guilty. So therefore he fled. And he's guilty because he knew that he possessed the gun. To echo Justice Merriman, it's a crime to possess a firearm without an ID. It's a crime to possess drugs. So by trying to say, well, we were using it to establish motive, it still goes back to, it wasn't secondary. It wasn't like, well, he did this because this. He is guilty because he's guilty. So it's not like he did this because, well, they have combined an essential element with motive, and the government is required to prove beyond a reasonable doubt intention and knowing. You cannot use a prior bad act to establish that he acted knowingly, to establish an essential element. And kind of going back to the trial court really should act as a guardian of evidence and to protect Mr. Pinaula's right to be tried based on the evidence against him. Not evidence of what he's done in the past, not a pending criminal case, and the trial court failed here. I don't believe that after the arguments were made that a limiting instruction would have cured the situation, but definitely would have made it better. And the government would have a stronger argument as to the prejudice that Mr. Pinaula faced. But that's not the facts that are before this court. What we have here is evidence of Mr. Pinaula's criminal history, and to kind of go back to this idea that they introduced this for motive. This is the government's argument. He's had different experiences. He understands how this works. That's not being offered for motive. That's being offered to tell the jury, Mr. Pinaula has been arrested so many times you can't even remember. Has a criminal conviction and he's pending felony and he agreed not to do all these things. The government's argument go against this idea that they introduced it for any other purpose than to establish that Mr. Pinaula is guilty because he's a criminal. With that, Your Honor, I think this court has an opportunity to to really get back to reminding parties that opening the door does not give you carte blanche. There are limitations. There has to be a nexus. And trial courts are still required to use the rules of evidence when it comes to the introduction of bad acts. And when it comes to weighing whether or not the probative value is greater than any undue prejudice that a party may experience through the introduction of that evidence. We ask that the court vacate the 2 convictions and the special charges, vacate all the convictions in this matter, and remand it back to trial court so that Mr. Pinaula can have a fair trial.
All right, thank you, Mr. Camacho.
Thank you, Your Honor.
Thank you, Mr. Tennyson. The court will take the matter under advisement. We'll issue a written opinion and will now stand adjourned.
All rise.